before this court for pre-taking and raised objection on the ground that they are civilians and therefore cannot be tried by this court. In reply, Councillor Shalan, the counsel for the state, submitted that jurisdiction to try a person not otherwise subject to military rule is provided under Section 117 of the UPDF Act. This court has looked at Section 117 G and H of the UPDF Act and finds that the chosen persons are subject to military law. The objection is therefore overruled. We so rule. And listen to the charge sheet. The Republic of Uganda, Uganda People's Defense Forces, the General Court Martial ordered at Maggye, Kampala, criminal case number UPDF TCM 040 of 2024. A charge sheet. Uganda versus A1 ROV 0098, Colonel retired Dr. Kizza Besigye, a male adult of sound mind, aged 67 years, resident of Kasanga Town, Nanga County, National Municipality of State District, a person subject to military law by virtue of Section 117, subsection 1HR of the UPDF Act, Cap 330, and A2 Hajj of age retired, male adult of sound mind, aged 65 years, resident of Mutual Village, Mutual Parish, marking the Sarala sub-county, the Zero County or State District. Person subject to military law by virtue of Section 117, subsection 1, HR of the UPDF Act, Cap 330, are hereby charged with statement of offense. Count 1. Offenses relating to security contract Section 128, subsection 1, F, the UPDF Act, Cap 330. Particulars of offense. Colonel retired Dr. Kizza Besigye, Hajj Objection Rotary, and others still at large between October 2023 and November 2024, while in cities to wit Geneva in Switzerland, Athens in Greece, and Nairobi in Kenya, held meetings aimed at soliciting for logistical support and identifying military targets in Uganda with intent to reduce the security of the defense forces. Colonel retired Dr. Kizza Besigye, have you heard and understood the charge related to the ground one?
They have.
And do you accept or do not accept?
Don't.
Have you not entered? Hajj Objection Rotary, have you heard and understood the charge related to the ground one?
Yes.
Do you accept or not accept?
I don't accept.
Have you not entered? Statement of offense on count 2. An unlawful possession of firearms under Section 4, subsection 1 and 2 of the Firearms Act, Cap 320. Particulars of offense. Colonel retired Dr. Kizza Besigye, Hajj Objection on 16th November 2024, while at Riverside, a apartments in Nairobi, Kenya, were found in an unlawful possession of a pistol model 27 KAL number 765, which is ordinarily the monopoly of the defense forces. Colonel Dr. Kizza Besigye, have you heard and understood the child electoral council?
I have.
Do you accept the interest?
Don't.
A period of not visited, entered the council. Hajj, the dear retired, have you heard and understood the child electoral council?
Yes.
You accept or don't accept?
I don't.
A period of not visited, entered the council. Count 3, statement of offense. Unlawful possession of firearms, total section 4, subsection 1 and 2 of the Firearms Act, Act 320. Particulars of offense. Colonel Retired Dr. Kizza Besigye, Hajj retired on 16th November 2024, while at the Riverside Apartments in Nairobi, Kenya, were found in an unlawful possession of a pistol HB 1014-1953, which is ordinarily the monopoly of the defense forces. Colonel Dr. Kizza Besigye, have you heard and understood the charge between on count 3?
I have.
And you accept or don't accept?
Don't.
A plea of not guilty entered. Hajj of the retired, have you heard and understood the charge between on count 3?
I have.
Do you accept or don't accept?
I don't.
A plea of not guilty entered on count 3. Count 4, statement of offense. An unlawful possession of ammunition under section 4, subsection 1 and 2 of the Firearms Act, Cap 320. Particulars of offense. Colonel Retired Dr. Kizza Besigye, Hajj of the retired on 16th November 2024, while at the Riverside Apartments in Nairobi, Kenya, were found in an unlawful possession of 08 rounds of crisp ammunition, which are ordinarily the monopoly of the defense forces. Colonel Dr. Kizza Besigye, have you heard and understood the charge read to you on count 4?
Yes, I am.
Do you accept or don't accept?
Don't.
A plea of not guilty entered count 4. Hajj, the dear retired, have you heard and understood the charge read to you on count 4?
I have.
Do you accept or don't accept?
I don't.
A plea of not guilty entered.
Investigation is asking the oil. I heard that the accused persons near the Maggye, accused person number 1 is in the government prison, and accused person number 2 is the kika in the government prison. And I heard that the defense bill and the judge for further information on the 2nd of December.
Confirm with the date register. Huh? Which date?
Chairman and honorable members. My name is Erias Lukwago. Wanda Maggye, Ronald Samuel, and Diane Finale. Mr. Chairman and honorable members, we are raising two objections, Mr. Chairman. One in regard to the order that has been issued regarding the demanding of the accused persons in separate facilities. We take exception to that. Mr. Chairman, we are going to the judge. As per the charge sheet, they were arrested together, they have been detained together. So it would be rational, Mr. Chairman, and unreasonable to remand them in different facilities. In other words, there is no justifiable reason for them to be remanded separately. The justice of the case will demand that since they are joined to the charge and they have to prepare a joint defense, they should be in the same facility where they can access their lawyers to effectively give instructions on how to manage this matter. It would be a great inconvenience to the accused persons and their lawyers to be in different facilities, Chitabi and Lusira, without having any point where they can converge and discuss their joint defense, because they are in one charge. So in the interest of justice, we pray that the order be revisited and they should be remanded in one place. The most fundamental objection, Mr. Chairman, relates to the nature of the proceedings before the honorable court. And that is our second objection. Mr. Chairman, regards it's about the propriety of these proceedings before the honorable court. It's our strong contention, Mr. Chairman, that these proceedings are invalid, considering the charges that have been preferred against the accused person. If I may be permitted to substantiate, Mr. Chairman, when we look at the particulars of all these 5 counts, 4 counts rather, they relate to offenses allegedly committed outside the jurisdiction of the honorable court. The first count talks about acts allegedly committed in Athens, Greece, Nairobi, and elsewhere. Mr. Chairman, this honorable court has no jurisdiction whatsoever to deal with offenses allegedly committed in Greece, Kenya, and Switzerland. Mr. Chairman, that applies to count 2, which talks about Riverside apartment in Nairobi, where it's alleged that on the 16th of November this year, the accused persons were found in possession of a pistol, model 27 KAL number 765. And also count 3, which talks about the same place, Riverside apartment in Nairobi, Kenya. And count 4, the same place, which talks about ammunition. It's nowhere in this charges, there is nowhere in this charge where it's alleged that all these acts, the impandi acts, were committed within the jurisdiction of this honorable court, that is the territory of Uganda. Mr. Chairman, this court has got no universal jurisdiction for the entire world. That would be stretching the jurisdiction of this honorable court to levels of absurdity. That it can deal with any matter that is alleged to have been done, or any act or offense that is alleged to have been committed anywhere in the world. I will refer you, Mr. Chairman, to the provisions of Article 28, Clause 7, which provides that no person shall be charged with or convicted of a criminal offense which is founded on an act or omission that did not, at the time it took place, constitute a criminal offense. So in this particular case, Mr. Chairman, all the acts referred to here in this charge sheet, or highlighted in this charge sheet, do not constitute criminal offenses within the meaning of the laws of Uganda. Because the UPDF Act applies to Uganda and doesn't apply anywhere else. The boundaries of its application, the boundaries of the UPDF Act, are the confines of the territory of Uganda. It does not extend to Kenya, neither does it extend to Switzerland or Geneva. It's not a law applicable there. It's the reason here, Mr. Chairman, in the charge sheet, which we find to be incurably defective. It does not make reference to the laws of those respective countries where these acts are alleged to have been committed. Unlawful possession of firearms, contrary to Section 4, subsection 1 and 2 of the Firearms Act, Cap 320. Firearms Act of which country? Because we are talking about here Riverside, Kenya. And in law, this is considered to be a duplex charge sheet, which is ambiguous in nature. So the accused persons cannot understand the nature of the particulars of the charge sheet as they are spelled out in these particular counts. Because, Mr. Chairman, you are talking about Firearms Act of which country? Then we are talking about in County 4 on on 16th of November 2024, while at Riverside Apartments in Nairobi, Kenya, Dr. Kizza Besigye and Maggye were found in unlawful possession of 8 rounds of pistol ammunition, which are ordinarily the monopoly of the defense forces. Of which country? Because we are talking about Riverside Apartment in Kenya. Are they a monopoly of the UPDF or KDF? In which case, this will determine the nature of the bully given by the accused persons as to whether the acts amount to an offense or not. So this is a defective charge sheet, Mr. Chairman, which should not sustain any criminal proceedings before this honorable tribunal. Lastly, Mr. Chairman, on count 1, offences relating to security, contrary to section 128(1)(f) of the UPDF Act, we presume this is Uganda People's Defense Forces Act of Uganda. That is the presumption, the rebuttable, depending on the evidence given by whoever is preferring this charge. but we presume that they meant the forces of Uganda. This is again an absurdity, Mr. Chairman. Because when you talk about acts under the particulars of the offense, which relates to acts allegedly committed in Geneva, Switzerland, Athens in Greece, and Nairobi in Kenya, and you relate them to the UPDF Act of Uganda, it's a nullity from the word go. So, Mr. Chairman, it's our prayer that this honorable tribunal be pleased to dismiss the charge sheet. Rather, no, sorry, to strike out, sorry, Mr. Chairman. So, there was two accused persons here traveled to Nairobi, lawful, for a legitimate activity, which was never in any way questioned by the security agencies, and were cleared by the immigration authorities of Uganda. So they have been in Kenya lawfully, or they entered Kenya lawfully. And Mr. Chairman, once you are in a foreign territory, you can only be returned forcibly through the due process of the law. If you do not return voluntarily, and there are forces compelling you to return, they have to follow the due process. And there are only two ways under the law. Either extradition, that is under the Extradition Act of Uganda, or deportation. In which case, Mr. Chairman, if it's about extradition, it has to be on a request of the Minister for Foreign Affairs that they are facing charges in Uganda here, and they are fugitives in Kenya, and they are demanding for assistance of the neighboring country to repatriate them back. We are not advised, it's not anywhere on record, Mr. Chairman, that has happened. It's not on record. If you are to be a deportation, it presupposes that they entered the country illegally, or having entered Kenya legally, they committed offenses in Kenya. Again, it would be the authorities in Kenya to handle that. And they have to go through the judicial process in Kenya. Deportation has to be by a court order given by the Kenyan authorities, Kenyan courts of law. So in this particular case, Mr. Chairman, the record does not bring out those facts, that they were either extradited or deported. And according to Mr. Chairman, the Human Rights Enforcement Act of Uganda, once proceedings are rooted in a narrative, Mr. Chairman and His Honorable Tribunal has no choice but to terminate the same. It's our contention, Mr. Chairman, that the accused persons have been illegally produced before you. They have not been repatriated, rather deported, neither have they been extradited. And if anything, Mr. Chairman, they have not been going through the immigration back here. As we stand today, they are presumed to be in Nairobi, in Kenya. The law presumes that they are still in Kenya. It would be a very, very absurd situation, Mr. Chairman, for this honorable court to sit here to handle cases or matters involving the two individuals who are currently standing in Nairobi. In the dock where they are standing here, the law presumes that they are in Nairobi, and the court is sitting in Uganda. So, Mr. Chairman, that is an absurdity which cannot be condoned by this honorable court, honorable tribunal. So, on those grounds, Mr. Chairman, we pray that you be pleased to strike up to the charge sheet, dismiss the case, set the accused persons free unconditionally, and have them discharged. We do so, please, Mr. Chairman.
And Section 208 of Uganda Equals Defense Forces Act, which is an act of parliament, states a person alleged to have committed a service offense may be charged or dealt with and tried under military law whether the alleged offense was committed in Uganda or out of Uganda. So to say that an offense which was committed after this in Nairobi and that section resolves that. My Lord Chairman and other members, on the issue of extradition, that can be addressed at it can be addressed. It can be his defense, and it should not be addressed at this stage. What is the evidence which has been produced before this honorable court that retired Colonel Dr. Kizza Besigye is supposed to be in there? That evidence has not been adopted before this honorable court. You are submitting on speculation. So, we pray that counsel be overruled and his prayer be dismissed. All of those are located on jurisdiction. The offense is committed in Nairobi. So I didn't want to hold it, but the whole thing is located on jurisdiction. Whether the offense was committed in Uganda or not. And this section of the law addresses.
Yes, Mr. Chairman. One is objecting on grounds that the UPDF Act provides for service offences to be tried by this honorable tribunal, whether committed here in Uganda or elsewhere. Mr. Chairman, the operative phrase here is service offence. And in this particular case, we're not talking about a service offence. Service offence under the UPDF Act means in the definition section, an offence under this act or any other act for the time being in force committed by a person while subject to military law. Mr. Chairman, in this particular case, they are talking about, the law talks about an officer or a member of UPDF who is in actual service. Literally, that's what it means. It's a service offense. And it's on record, it's not in dispute that the accused persons are not members of the UPDF. Therefore, they are not amenable to charges of that nature, which are service offenses. So, Chairman, the other argument is neither here nor there. And it's indeed really fair that it can only be raised in defense. Mr. Chairman, it is the prosecution to make out its case. Sufficient particulars must be given, warranting the accused person to be put to their defense. So we are at a stage where the state must bring these facts before this honorable tribunal before you talk about the defense. It is the UPDF that is charging the accused person. It is the same institution that presumably arrested them. And that's the fact. So it would be, again, very unreasonable for the prosecution to ever imagine that actually the onus is on the accused persons to bring evidence regarding their arrest. It would be very, very unreasonable. When actually it is the UPDF, under the UPDF Act, which has this tribunal, and they are the ones prosecuting the accused persons before this tribunal. They are the ones who arrested them, and they are the ones who are supposed to bring this evidence. So the presumption is that actually the tribunal has these facts, because it's an integral part, the tribunal is an integral part of the institution of the UPDF, which presumably is the one which conducted the arrest, and I call it arrest in quotes, advisedly, because the accused did not bring themselves before this honorable tribunal. They were compelled by the UPDF. So, we are not obliging at this material time, Mr. Chairman, to produce the kind of evidence he is talking about. Again, the rest of the issues have not been rebutted. We have raised the return of objections, and we're not surprised that they have not responded. They have not rebutted the same. We pray that Mr. Chairman, you take them as facts, and you take them as uncontroverted prayers, which ordinarily should be granted. We reiterate our earlier prayer that you be pleased to strike out the charge sheet, because all our objections in regard to the duplicity and the illegality of the charge sheet have not been controverted. They have not been rebutted. So they remain unchallenged. And there is a word of authorities that once matters are unrebutted, they are taken for what they are as matters of fact, which should be accepted by court and the decision made accordingly. So we pray that your worship, Mr. Chairman, you grant our prayers that we earlier made. We do so. We leave it to court.
So maybe, sir, have you heard from both sides, the state and the lawyers? I think ordinarily the law requires that objection to the charge must be taken before a plea. And the counsel has raised the matter after the accused have pleaded the charges. And this court is unable to give a ruling on this matter now. So I advise that they can be remanded and the ruling of court will be given in the next hearing date. Then the issue of remand, I think the court can consider the prayer made by counsel Lukwago.
Council, that your submissions have been taken seriously, and the court is adjourned to 2nd December 2024 for mention and ruling on what you have submitted on. And also, the accused persons
hereby commanded to the government to do so.
Such a